Statement of charge. John Chuck Jr., the defendant in this case, has been accused of murder in the first degree. Introduction to homicide. In this case, John Chuck Jr. is accused of murder in the first degree. Murder in the second degree includes the lesser crimes of murder in the second degree. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Phoebe John Chuck was killed by John Chuck Jr., you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the first degree or was murder in the second degree manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by unlawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune. I was hoping I would have a bottle of water. My fault, I don't. I'm break. 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. I now instruct you on the circumstances that must be proved before John Chuck Jr. may be found guilty of murder in the first degree or any lesser included crime. Murder in the first degree. There are 2 ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Phoebe John Chuck is dead. 2, the death was caused by the criminal act of John Chuck Jr. 3, there was a premeditated killing of Phoebe John Chuck. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether John Chuck Jr. did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused the death, and E, John Chuck Jr. was in fact so provoked and did not cool off before he committed the act that caused the death of Phoebe John Chuck. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. Felony murder, first degree. To prove the crime of first-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Phoebe John Chuck is dead. 2, while engaged in the commission of an aggravated child abuse, John Chuck Jr. caused the death of Phoebe John Chuck. 3, John Chuck Jr. was the person who actually killed Phoebe Johnchuck. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of aggravated child abuse, the state must prove the following two elements beyond a reasonable doubt. 1. John Chuck Jr. knowingly or willfully committed child abuse upon Phoebe Johnchuck and in so doing caused great bodily harm to Phoebe Johnchuck. 2. Phoebe Johnchuck was under the age of 18 years. Willfully means intentionally and purposely. Child abuse means the intentional infliction of physical injury upon a child or an intentional act that could reasonably be expected to result in physical injury to a child. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he's accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree are murder in the second degree and manslaughter. Lesser, murder in the second degree. To prove the crime of second degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Phoebe Johnchuck is dead. 2. The death was caused by the criminal act of John Chuck Jr. 3. There was an unlawful killing of Phoebe Johnchuck by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict a second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Lesser manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Phoebe Johnchuck is dead. 2. John Chuck Jr. intentionally committed an act or acts that caused the death of Phoebe Johnchuck. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any unconscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. Insanity. An issue in this case is whether John Chuck Jr. was insane when the crime allegedly was committed. A person is considered to be insane when 1. He had a mental infirmity, disease, or defect. 2. Because of this condition, A. He did not know what he was doing or its consequences. Or B. Although he knew what he was doing and its consequences, he did not know it was wrong. All persons are presumed to be sane. The defendant has the burden of proving the defense of insanity by clear and convincing evidence. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation about the matter in issue. In determining the issue of insanity, you may consider the testimony of expert and non-expert witnesses. The questions you must answer is not whether the defendant is insane today or has ever been insane, but whether instead the defendant was insane at the time of the crime, at the time the crime allegedly was committed. Although insanity is a defense, mental or psychiatric conditions not constituting insanity are not defenses to any crime in this case, unless there is clear and convincing evidence that John Chuck Jr. was insane at the time of the crime alleged. Any evidence of mental illness, an abnormal mental condition, or diminished mental capacity may not be taken into consideration to show that he lacked the specific intent or did not have the state of mind essential to proving that he committed the crime charged or any lesser crime. If you find that John Chuck Jr. committed the crime, but you find by clear and convincing evidence that the defendant was insane, then you should find him not guilty by reason of insanity. If your verdict is that the defendant is not guilty by reason of insanity, that does not necessarily mean he will be released from custody. I must conduct further proceedings to determine if the defendant should be committed to a mental hospital or given other outpatient treatment or release. Or given, say that right, psychotropic medication. John Chuck Jr. currently is being administered psychotropic medication under medical supervision for a mental or emotional condition. Psychotropic medication is any drug or compound affecting the mind, behavior, intellectual functions, perception, moods, or emotion, and includes antipsychotic, antidepressant, anti-manic, and anti-anxiety drugs. You shall not allow the defendant's present condition in court or any apparent side effect from the medication that you may have observed in court to affect your deliberations. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial. And it's actually allegation in the indictment. Through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. Does anybody want me to have any members of the jury change information to indictment? No. Nope. Okay. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or of having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Did the witness at some other time make a statement that's inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses that is called or upon the number of exhibits it's offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It's entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It's not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It's up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You cannot view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. Excuse me, in making this determination, you should consider the total circumstances included but not limited to: 1, whether when the defendant made the statement he'd been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply to your discussion. You must follow the rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror has to agree to the same verdict. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. The jury is not, excuse me, number 8, the jury is not to discuss any question that a juror wrote that was not asked by the court and must not hold that against either party. 9, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I can't participate in that decision in any way. Please disregard anything I might have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty by reason of insanity. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to the crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And I know you can't see it from where you are. It actually is relatively simple compared to some. Murder in the first degree, State of Florida versus John Johnchuk. We, the jury, finds as follows as to the defendant in this case. Check, only one. I don't mean the case is simple, I mean the verdict form simple. A, the defendant is guilty of murder in the first degree as charged. B, the defendant is guilty of murder in the second degree, a lesser included offense. C, the defendant is guilty of manslaughter, a lesser included offense. D, the defendant is not guilty. E, the defendant is not guilty because legally insane. And then there's a space for the foreperson that you select to sign, print, and date the verdict form when you've all decided on a verdict. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your decisions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all the jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you've reached a verdict. You can't talk about the case in person, through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Don't contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in the case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of electronic devices into the jury room. That last sentence is incorrect. You don't leave them on your seat, but there's going to be a bucket outside the, you've probably already seen the bucket, and I don't even have to tell you. There's going to be a bucket outside the jury room, and you're all just going to dump all your stuff in there. When you start to deliberate, there will always be a deputy outside that door. There will never not be one. So your devices will be safe, and if you have any questions or issues, all you have to do is knock, and it will be immediately answered. If you need to communicate with me, send a note through the bailiff. If you have voted, don't disclose the actual note in the note, the actual question, the actual vote in the note. If you have a question, I will talk with the lawyers before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you don't like the laws that must be applied, you must use them. For more than 2 centuries, we've lived by the Constitution and the law. No juror has the right to violate rules we all share. Any issues with the jury instructions?